Hi there, and welcome to our 5-minute webinar series where we cover important topics in about 5 minutes. Today we're going to talk about the current paid sick leave rules under the Families First Coronavirus Response Act. Released in March 2020, the Families First Coronavirus Response Act is the first piece of legislation that is designed to provide programs to help individuals and their families during the COVID-19 pandemic. This includes providing paid sick leave, tax credits, and free COVID-19 testing, as well as expanding food assistance and unemployment benefits, and increasing Medicaid funding. We're going to be spending today talking about the paid sick leave program under the Act. Now, one of the more prominent initiatives in this bill requires certain employers to provide their employees with paid sick leave and expanded family and medical leave for specific reasons related to COVID-19. There's a lot of specifics around this, so let's try and outline what's in here. So what are the reasons for qualifying for paid sick leave? Well, the Department of Labor has a nice little table here. An employee is entitled to take leave related to COVID-19 if the employee is unable to work, which includes unable to telework, because of the following reasons. If the employee is subject to federal, state, or local quarantine or isolation related to COVID-19, or has been advised by a healthcare professional to self-quarantine related to the virus. Anybody who's experiencing COVID-19 symptoms and is seeking a medical diagnosis. Someone who's caring for an individual on isolation order or needs to self-quarantine. Is anybody who's caring for his or her child whose school or place of care is closed, or child care provider is unable due to COVID-19 reasons, or is experiencing any other substantially similar condition specified by the U.S. Department of Health and Human Services. So the Department of Labor's Wage and Hour Division is really looking to be very specific about what would constitute a COVID-19 or COVID-related instance to stay out of work. Based on these criteria, it's the employer's responsibility to provide paid leave. However, the recent interpretations of these criteria state two important distinctions. The first is that employees only will qualify for leave if the employer has work for them and they are unable to do it. The second is around childcare. Leave for childcare is only available if there are no other sources of childcare, like a relative, and not just because the facility the employee used is closed. So if you can find childcare and you have the ability to do it, you're not eligible for that leave. And it's really important to review all these kind of distinctions with some legal or financial advisor in general. We found that the interpretations on these laws are constantly changing and evolving as more time passes. So it's important to kind of stay in touch with how the DOL and your legal folks would interpret these. So what exactly is the employer expected to provide in these circumstances? Well, the Act says that generally employers covered under this Act must provide employees up to 2 weeks, 80 hours really, or a part-time employee's 2-week equivalent of paid sick leave based on the higher of their regular rate of pay, or the applicable state or federal minimum wage, and it's paid out based on the difference criteria we just illustrated before. So if you meet numbers 1 through 3 in the table, which cover individuals who are under isolation orders or advised to quarantine or have COVID-related symptoms, you will receive 100% of your 2 weeks leave, but up to $511 daily or $5,100 in total. Now, if you meet criteria number 4 and number 6, which really center around less direct impacts, such as caring for individuals that are under isolation or similar symptoms to COVID-19, but not COVID, they get 2/3 of the paid time, up to $200 daily and $2,000 total. Now, the last one's really interesting. It's one that I think might come as a surprise, but for those employees that are caring for a child whose place of care is closed or they're under isolation, these folks are entitled up to 12 weeks of paid sick leave and expanded family and medical leave paid at 2/3 their pay rate, up to $200 daily and $12,000 total. So there's a significant amount of time and money that employers are expected to provide their employees at this time, but it doesn't apply to all companies. The eligibility of this program is designed to support most of the employees and their families within the small business community. In general, employees of private sector employers with fewer than 500 employees and certain public sector employers are eligible for this paid leave program. Another restriction is that only those employees who have been employed for at least 30 days prior to leave may be eligible for that additional 10 weeks of that partially expanded family care for reasons number 5. That was the child care reason. And part of the criteria states that if you are able to work from home or telecommute, you're not eligible. So that's an important distinction. On the other side, the rest of the paid leave rules apply for all employees, even if they were employed for one day. The last part to be aware of is that employers, including religious nonprofits with fewer than 50 employees, can be exempt from providing either both emergency paid leave and emergency care leave to their employees if it would jeopardize the viability of that small business. Now, however, be careful about this exemption. You need to prove that this is the case. Denying any emergency paid leave will ultimately cause issues, and if you can't back this up, you're going to have more challenges than benefits. It's really important that you talk to your tax and your legal advisors to make sure you understand what it means that you're jeopardizing the viability of your business. So what's the effective date and what should an employer be expected to do here? Well, the plan took effect on April 1st, 2020, and employers that have less than 500 employees will need to comply with these rules. It's really recommended that employers make documentation and records of these employee requests to ensure that they are receiving their pay during that time. There's a lot of news going around about law firms have said there's going to be litigation disputes over these paid leave rules because they are so new and they do have a lot of different types of rules around them. And really, employers should make sure they have records of these compliance to these rules for any future legal issues that may arise. In addition, work with your payroll provider. Ensure that you have proper deductions are in place when you actually are instituting these paid leave programs. Now, currently, the Department of Labor is not going to enforce these violations until April 17th, 2020. As long as an employer makes reasonable good faith efforts to comply during this time. So I hope you enjoyed this brief overview. I've added a few links here for more information about the legislation and some other resources. I also recommend you review our video on the other piece of legislation, the CARES Act and the Payroll Protection Program. The best advice is to work with your tax and legal advisors on the best programs for your business and reach out to your payroll provider for some help. They've been working on these for quite some time now, and they have some interesting advice for you. So good luck and be safe out there.